for joining us again. I'm really excited to be able to welcome back my favorite land use attorney, Ken Stahl from Miller Star Regalia, and from the faculty at the Chapman University Fowler School of Law to give us the third in an update on the Builder's Remedy under the new law AB 1893 by Assemblymember Wicks that was just signed off on in the last month. So I'm going to go ahead and turn it over to you, Ken.
Well, thank you so much, Elizabeth. It is wonderful to be here with all of you. Sorry about that. It's wonderful to be here with all of you. This is, as Liz said earlier, the third in my series of webinars for People for Housing about the Builder's Remedy Law. The first two, I'll provide some links to you in just a moment. Sorry, I'm just not locating the presentation. Okay, just a moment. Here we go. Okay, great. So I will, this will be an update to my previous Builder's Remedy presentations. For those of you who don't know or aren't familiar, the Builder's Remedy is a name commonly given to a state statute that falls under a broader law called the Housing Accountability Law. It is, I think, one of the state's signature housing laws. Designed to spur housing production in the state. But there have, for the last several years, been a lot of uncertainties and ambiguities about the law. And now with AB 1893, some of those ambiguities have been cleared up. So just note, this is not going to be a full introduction to the Builder's Remedy Law. That's why I post the links to the two previous webinars, and I will refer to those from time to time. So for those of you who feel like maybe you're falling a little behind because you aren't familiar with all the terminology, you should feel free to check out my other webinars. I'll just start with a quick introduction about myself, which you can see here. My full-time job is I'm a professor of law and the director of the Environmental Land Use and Real Estate program at the Chapman University Fowler School of Law. I also work part-time as a land use attorney with Miller Star Regalia. And my specialty has really been state housing law, particularly the Housing Accountability Act. I've been involved successfully with litigation under the HAA, as well as advising developers on the entitlement process and the protections of state housing law, including the Builder's Remedy. And of course, I've been working with People for Housing for many years now. I've absolutely been delighted with my working relationship with Liz and all the other folks at People for Housing. And I'm really glad to be able to do this series of webinars. So let me just start with the really key takeaways for today, because it's going to get pretty nuanced and detailed. So I want to try to make it as accessible as possible. The first big takeaway, and this is probably, if you've heard anything about the changes to the Builder's Remedy Law, you've probably heard this, that the new law trades lower density maximums for lower affordability requirements. That's kind of the trade-off. But I think that sort of headline masks a lot of what the Builder's Remedy Law is doing, because it also does a lot of other stuff that I think may be equally or even more valuable. So for one thing, the new Builder's Remedy Law reduces a lot of the uncertainty and gamesmanship that we've seen in the process for the last few years, and also improves the process in a variety of different ways. I'm really excited about the ways in which it gives more options to make SQUL manageable, and I'm going to talk about those more towards the end of the presentation. There are, though, of course, some questions and what the social media types like to refer to as California brain stuff, where under the guise of doing things that are progressive, we actually work against affordable housing goals. So we'll talk a little bit about that. Is it better, right? This is the big question a lot of people are talking about. Which is better, the new or the old? Who cares, right? The new is what we have, and it's what we have to work with. There's a lot of good stuff in there, and time is going to tell how good it is. I'll start with also with a little bit of a caveat here, just so everybody understands, of course, that this presentation is not legal advice. The Builder's Remedy Law is very site-specific. So I can't really say very much without knowing the specifics of a particular project and a particular site. And as you're going to see shortly, I'm not going to have to say much more about this now. The new law is extremely complicated and full of details. So you'll see very quickly that it's really important to consult with me or another land use attorney before you think about pursuing a Builder's Remedy project, because it is super complicated. Okay, so before diving into talking about some of the changes to the builder's remedy law, I want to talk a little bit about the old builder's remedy and what it did. So under well, it's still the existing builder's remedy until January, the law was extremely sparse. It literally just said jurisdictions cannot deny or unreasonably condition any housing project containing at least 20% affordable units on almost any site. Even if the project is inconsistent with the general plan and zoning standards, if the jurisdiction does not have a substantially compliant housing element. So that's really all that there was to it. And that left a lot of questions, some of which I'm going to talk about in a moment, but also a lot of opportunities because the clear upshot was, again, cities just cannot deny almost any project on any site with 20% affordable housing units if the jurisdiction didn't have a substantially compliant housing element, and many jurisdictions did not. So this is a subject I covered in some depth in my 2 previous webinars. You can see the links here on this page. I just want to alert you, though, that because of what I'm going to be saying today, a lot of what's in those 2 previous webinars has become completely obsolete, and a lot has changed. Where I think the previous webinars are most useful is in dealing with the process of filing a builder's remedy application. There are some changes to the process, which I'll talk about, but the basic process is very similar. So you might look back to those previous webinars for some of those things. And again, I might kind of refer to the previous webinars on occasion here. Okay. Again, lots of questions under the old builder's remedy. We didn't even know what substantially compliant meant, right? Now we have some clarity about that, although AB 1893 does raise some new questions. Now, before I get into the new law and how it's similar and how it differs from the old, I want to first talk about how this is going to be relevant for builders who are already pursuing a builder's remedy application under the existing law. Because I know probably a lot of folks who are on this webinar are in that situation where you currently have a preliminary application for a builder's remedy project. Now, again, preliminary application under the Senate Bill 330 is something I discussed in the previous webinars. That's one of those procedural things. So I'm not going to talk in detail today about what a preliminary application is or how it works. I'm going to kind of assume that you're aware of what that means, but feel free to check my previous webinars on that. So any project that has a preliminary application under SB 330 submitted before January 1st of next year is going to have 2 options. One is you can stick with the existing builder's remedy, the one that's in force right now, or you can convert your project to a new builder's remedy project under the new process of AB 1893. Crucially, and this is at the bottom of that slide there, I know it's a lot of text. Normally, if you change your project by more than 20%, the density of the square footage changes by more than 20%, between the preliminary application and when you file your full application, you will lose the vesting rights under SB 330. But AB 1893 changes that. You can convert your project from an existing builder's remedy application to a new builder's remedy application and keep your vested rights, even if the application changes by more than 20%. I'll say a little bit more later about the vested rights, but this is great because it means, again, if you have a builder's remedy on file, preliminary application on file right now, or you're planning on filing one between now and the end of the year, you will have the option of using either the old or the new. Obviously, if you use the new, if you wait until after January 1st, you'll only be able to use the new process. Okay, so what hasn't changed? Let's start with that. It's a little easier to talk about than what has changed. Builder's remedy is triggered if the city does not have a substantially compliant housing element, and the law, as we'll see momentarily, actually clarifies what it means to have a substantially compliant housing element. Now, we're now in a situation, a couple of years after my previous webinars, where many cities now do have substantially compliant housing elements. But that doesn't mean you should totally lose hope. State law also applies special requirements to sites that are listed in the housing element site inventory. The housing element is not supposed to be a way for cities to avoid building housing. It's supposed to be a way for them to commit to building housing. So there are still advantages you can get if your project site is in the housing element site inventory. So you'll want to check that. I'm not going to be covering that in this webinar because there's just too much to talk about, but I might have another webinar about that sort of other piece, what I'm calling the builder's remedy light, where a project site is in the housing element inventory. Also, even if your site isn't in the inventory, there's a lot of other good stuff in the Housing Accountability Act aside from the builder's remedy. And AB 1893 makes a lot of changes to other parts of the HAA that are also really useful, particularly with regard to the process of getting a completeness determination from cities under the Permit Streamlining Act. Again, not going to cover that in this webinar, but hopefully have a chance to cover that in a future one. Okay, so let's talk about what has changed. This is just a quick list of some of the things that I'm going to go into and the basic changes. So let's just get right into it. And again, I'm going to apologize to you right off the bat. There is a ton of text here. There is just no other way to do it. I hate using lots of text. My students know I hate using PowerPoints with lots of text, but there's just no way I can convey all of this information to you without showing you lots of text here. But I'm going to try not to just kind of read everything right off the screen. Okay, so let's start with density maximums. I know that's one of the big ticket items everyone's thinking about. Under the existing builder's remedy, there's no limits on density, right? You could propose a project as dense as you want under the existing builder's remedy. The new builder's remedy law actually has a formula for determining the maximum density, but it's still, I think, pretty generous. Developers get to choose the greatest of three options. So the first is 3 times the density provided on the site by the general plan, zoning, or state law. So, right, if your site is zoned for 10 units an acre, you can do 30 units an acre. Second, the site density prescribed in the housing element. So again, you'll want to look at the housing element. I think this is going to be, less likely for most projects because by definition, your jurisdiction does not have a compliant housing element. But it's possible they have a draft housing element or the earlier 5th cycle housing element. I think what's most likely for most projects is you're going to use the third one here, which is 150% of the state prescribed minimum density for low-income housing, what's known as the Mullen density. This is a number that's prescribed for jurisdictions based on their level of urbanization. So in most very urbanized or what's called metropolitan areas, the Mullen density is 30 units per acre, meaning 150% of that, 45 units per acre is going to be the maximum base density for most builders remedy projects, 45 units per acre. I say base density because note the next bullet point there. You can also add density bonus units on top of that. Now, as we'll get to in a couple of slides, of course, to qualify for builder's remedy, you're going to have an affordable component to the project. So those affordable units will count towards a density bonus. So for example, if you choose to provide 13% low-income housing, which is one of the thresholds prescribed, that gets you a 24.5% density bonus, or if you're using the 45 unit max, an additional 11 units. So that gets you up to 56. Okay, so there's a lot of different ways you can kind of max out the density with the new law. And then you also see here at the very last bullet point, you can actually tack on to that an additional 35 units in certain areas if you're near transit, low VMT areas, and so on. So it's complicated, but and you're not going to get the unlimited density as before, but you can put together pretty good density on many of these sites. A builder's remedy also specifies now for the first time minimum densities in some cases. Okay, minimum densities are only going to be required on sites that already have a minimum density requirement. Or if the site you're looking at doesn't have a minimum density requirement, then there is no density minimum. Okay, if the site does have a minimum density requirement, then in most cases, you can choose one of two, whichever one's lower, the lowest minimum density permitted in the jurisdiction, or 50% of that Mullen density. Again, remember the Mullen density is 30 units per acre. 50% of that is going to be 15 units. So you would choose one of those two, whichever one's lower. not necessarily the site density, right? But one of these two. And then for sites that are near certain train stations, you have to actually equal or exceed the actual minimum site density. Affordability, this is the other big item, and you see again, there's a ton of text here, lot to go over here. Under the old builder's remedy, the existing builder's remedy, it was a flat requirement. 20% of the units have to be affordable for low-income households, or 100% for moderate. Right now, it's much more complex, but the affordable percentages are somewhat more generous for the developer. So you can see the first slide, the first bullet point, you have the choice of 7% extremely low income, 10% very low, 13% lower income, or 100% moderate income, right? Those are the choices. I just want to make a quick note, which is these income categories as defined in the builder's remedy law are not exactly the same as the HUD definitions, right? California always has to do things a little bit differently, right? So, for example, HUD defines lower income as households making 80% of the area median income, but the builder's remedy law defines it as 70% for sale housing and 60% of the area median income for rental housing. Again, I'm certainly not expecting everyone to remember all of this stuff. This, again, is why you'll want to consult with an attorney and maybe watch this video afterwards to get all the little details. But just kind of trying to give you an overview. All right, so that's kind of the basics there. But don't forget, you also get your density bonus, right? You can tack that on top of the base density there. Also, the third bullet point I love, I think this is going to be huge. Most projects of 10 units or fewer are totally exempt, excuse me, from the affordability requirement. So that is to say you can do 10 units or fewer, and in most cases, no affordability requirement. The most California brained thing in here is that the bedroom and bathroom counts have to be comparable to the market rate units. Again, this is one of those things that California does where they feel really good about, legislators can feel really good about themselves that they're making sure that lower income households have all the same amenities that market rate households have, which is great in principle. But of course, what it really means is that fewer lower income households are going to get housing. But regardless, that is what we have for right now. The bedroom and bathroom counts have to be comparable. Now, I want you to notice the very last bullet point because it's really interesting, and I'm actually going to pull that one out here to a separate slide. Cities can actually apply their own local affordable requirements in addition to the state ones, up to 20%. But if they go all the way up to 20%, they can't require any deeper affordability than lower income. Right, so even though state law says, for example, 13% low income, cities can go up to 20. That sounds bad, but note the second bullet point here. Cities have to prove feasibility, and they have the burden of proof by a preponderance of the evidence, meaning more likely than not, they have to prove that it's feasible. I personally think that's going to be really difficult to do. Right, because what's going to happen here is the city will have a feasibility study showing that it's feasible. The developer will commission a feasibility study showing that it's not. And it'll be a battle of the experts in which, in most cases, a court would have to conclude it's not more likely than not that it's feasible. What's also interesting here is that a city cannot apply any other feature of an affordability requirement other than the objective numerical percentages and the income category, lower income, very low income. So, for example, if a city has a requirement that the lower income units have to be dispersed among the market rate units, or that they have to be a particular size, or they have to have all access to all the same amenities, cities aren't going to be able to apply any of those other features of their local inclusionary rules, which today there is some question about, and some jurisdictions do try to enforce those rules against builder's remedy projects. I'll just say as a note here, by the way, many of these other requirements, the examples I just gave, would probably not be allowed anyway under the Housing Accountability Act because they're not objective. But regardless, the new law makes clear that those other features aren't permitted to be included. Okay, so that's affordability. There are some additional site requirements now. In the old days, you could really do anything with a few narrow exceptions. The one change here is that your site can't be abutting a heavy industrial site. By the way, I meant to change that slide to say heavy industry. So light industry is okay. Heavy, you cannot be abutting a heavy industrial site. But interestingly, the site itself can be zoned industrial. You just can't be next to one. So that's the site rules. Let's talk about local development standards. Under the existing builder's remedy statute, there were some questions about whether jurisdictions could apply, other development standards like setbacks and parking requirements and things like that. The new law clarifies this somewhat. It says that cities can apply objective, quantifiable written standards applicable to sites in the jurisdiction where the density and unit count being proposed are permitted. So that maybe gives cities some additional leeway to impose additional requirements, except, of course, they do have to be objective, as noted here. But keep in mind, first of all, as you see in that next bullet, the city again has the burden of proving that any standards it applies do not render the project infeasible or preclude construction. And then second, and I love this one, the applicant can modify standards with the density bonus law. Remember, well, for those of you who are familiar with the density bonus law, that affordable housing doesn't just get you a density bonus under the density bonus law. It also gives you what are called concessions or incentives or waivers that permit you to vary from certain local development standards. And as we'll see momentarily, the new builder's remedy actually gives builder's remedy projects 2 additional density bonus concessions. Say for a project that has 13% low income, which again would be one of the mandatory thresholds under the builder's remedy law, you would normally get, I believe, 1 concession, but now you would get 3. And you can use those concessions to vary any of the city's standards that would would increase costs for the project. So with those 2 bullet points, the developers have a lot of ammunition when cities are attempting to oppose these standards. There is some question here about what happens if there is no general plan or zoning designation that allows the project as proposed. Then what standards do you use? The law seems to suggest that developers can propose what standards to use, but it's a little bit of a gray area. The process is what I'm really excited about here for, what I'm really excited about with the AB 1893. Sorry, excuse me a moment. Lost my presentation again. Let me get it back. Yeah, here we go. Okay. So again, the builder's remedy law currently is very sparse, doesn't say a lot about any particular procedural rules. The new law has a ton of process stuff and clarifies a lot of things that had been the subject of a lot of fights between cities and developers. So we now know cities cannot require a general plan amendment or a rezoning for a builder's remedy project. This was actually a question someone asked me at one of the previous webinars I did, and I think at the time I said, we just don't know if they can do that or not. Now we know they can't. They can't. Cities also cannot apply any standards to builders remedies projects that they would not apply to non-builders remedy projects. I mentioned earlier, you get 2 additional density bonus concessions. You can see I'm excited about that. Cities also cannot hold more than 5 hearings. This is a law that was already in place for projects that are consistent with all of a jurisdiction's objective standards. Now it's being applied to builders remedy projects too. No more than 5 hearings or engage in conduct that is designed to frustrate a builders remedy project, or the jurisdiction can be sued under the Housing Accountability Act. More process stuff. This stuff actually comes from a companion bill called AB 1886 that, again, clears up a lot of things that were kind of unclear. So first of all, a housing element is only substantially compliant if a court or the state Housing and Community Development Department says so. Right? So a jurisdiction cannot self-certify, nor can it make the argument that after HCD has approved the housing element, well, that means that our housing element was substantially compliant when we adopted it 3 months ago. No, it's only substantially compliant once the court or HCD says so. Now, on my read, AB 1886 doesn't say what happens if HCD says the HE is compliant, but you think it's not. This was the fact pattern in the case of Martinez versus City of Clovis. HCD said that the city had a compliant housing element. The plaintiff in that lawsuit sued Clovis and said that it wasn't. The court agreed with the plaintiff that HCD was wrong and the jurisdiction did not have a substantially compliant housing element. Again, AB 1886 doesn't address that, so I think that argument can still be made. Now, it's an uphill battle. If HCD has said that a jurisdiction's housing element is compliant and you think it's not, a court will probably be pretty deferential to HCD, but it's not conclusive. Second, substantial compliance is determined as of the date of a submitted SB 330 preliminary application. So when you file that preliminary application, it vests your rights under the builder's remedy. Meaning, if you file the preliminary application at a time when the city or county does not have a substantially compliant housing element, then you have sort of frozen or vested your rights to pursue the builder's remedy application. Importantly, both of these changes are declaratory of existing law, meaning these two provisions also apply to existing builder's remedy projects, not just to new projects. So again, those of you who have a preliminary application on file right now, or who are going to be filing one before the end of the year, you will still be able to take advantage of these two provisions of AB 1886. So love that. All right, last item on my agenda, which is good because I think I'm getting to my time here. SQUL. Now, the builder's remedy statute, for everything that it kind of allowed you to do in terms of local standards, did not provide any SQUL exemption per se. There was last year a really important bill called AB 1633, which prevents some SQUL gamesmanship. So, for example, AB 1633 would prevent a city from denying you an exemption if you clearly qualified for it. Previously, cities could say, well, I don't know, I'm going to send it back for some more SQUL study. If you qualify for an exemption, you get it. But that meant that you had to qualify for an exemption. The builder's remedy doesn't actually provide an exemption. And there were also some questions about whether you could actually combine the builder's remedy with SQUL exemptions, particularly the infill exemption. Some of those questions are now resolved. First of all, it's now been clarified that you can combine the builder's remedy with statutes like AB 2011 or SB 35, which provide SQUL streamlining. In essence, a SQUL exemption plus a streamlined process of approval. And in fact, you can use those laws even if your project doesn't meet the density maximum or minimum in those statutes, as long as, of course, you're meeting the density maximum or minimum in the builder's remedy law. So if you can combine builder's remedy with AB 2011 or SB 35, then you get a SQUL exemption and an expedited process. Also, the new law states that builder's remedy projects are deemed to comply with all applicable standards for all purposes, which I think clearly indicates that they are eligible for the Class 32 infill exemption. One of the requirements for the infill exemption is that you meet all of the applicable local requirements. And since the builder's remedy statute says builder's remedy projects are deemed to comply with all applicable local standards for all purposes, I think it's pretty clear now you can get the Class 32 infill exemption. And you can use Class 32 with AB 1633, right? So if you've qualified for that infill exemption, then you can push the city to make sure you get it. The advantage of doing that, the infill plus AB 1633, is you don't have to pay prevailing wage for construction work, whereas the streamlining processes under AB 2011 or SB 35 would require the use of prevailing wage, and in some cases, the skilled and trained workforce. And so that's it. I'm just going to wrap up quickly. Yeah, fewer cities are subject to builder's remedy for now. Although we're starting to see that at least one city is having its housing element D certified, and I think others are almost certain to come. So yeah, there are fewer cities subject to builder's remedy, but that list may grow, and the penalties I think are somewhat more severe. The process changes are great, in my opinion, making it harder and harder for cities to play games with builders remedy projects, more options for developers. I really think the sleeper thing here is going to be small projects of 10 units or fewer. Because the thing, we've seen previous sort of missing middle type bills like SB 9, but they always put these like poison pill things in there that make them impossible to use. But this one seems to be missing any poison pills for the 10 units or fewer. So I think that's going to be really, really good. And as I just talked about, combining builder's remedy with other state housing laws like density bonus or SB 35 or what have you are really going to make it pretty potent. So that's my presentation. I'm not above promoting some of my rivals here. So a few other law firms, Holland Knight, Allen Matkins, Cox Castle, have done some great write-ups about AB 1893, as have the folks at California YIMBY. So please check out those resources as well for additional information. Of course, feel free to call me or email me for information if you want to talk about a specific builder's remedy project or just generally about builder's remedy. And then the last slide here is for People for Housing. I know that Liz and Natalia and the folks at People for Housing are very interested in getting your feedback about how you like the webinar and how you like their hosting service. So please do stick around and fill out that evaluation. And I will be here to answer your questions. So thank you so much for your time. Look forward to hearing what you thought.
Thank you so much, Ken. This was awesome. I learned something from you every time you open your mouth. So I'm so grateful for your time. We do have time. So if folks we're scheduled to go till 1. So if people do have questions, if you want to put them in the chat, how many are we? We're almost 50 people on this call right now. So that's a lot of people to come off mute at once. But if somebody does have a question and you want to raise your hand, we can certainly take questions if people want to ask a burning question that they don't want to call or email. Where can we get a video recording of this? That is a question for me. We will upload this recording and it's on our YouTube channel. We have a YouTube channel. That's where Ken's other 2 webinars live. They live on our YouTube channel. And we'll be happy to send out the link as well. All right. We have a question I'm going to read. This says, you mentioned that low income is defined as 60% of area median income in AB 1893. I thought it was still 80%, and in reviewing the bill, I don't see where it cuts it down. Can you walk me through that?
Yeah, so rental is per Health and Safety Code section 50053, which defines low income as very low income as 30% of 60%.
Got it. Thanks. I had seen the reference to 5079.5, which I think is in there somewhere else.
Yeah, but Nick, it's obviously since this is new, it's possible I got it wrong. So please let me know if I did. But that's where I'm getting that info from.
No, that makes sense. I'll look into it, but
Okay.
thanks for pointing that out.
All right. This one says, any advice for using this information and the threat of builder's remedy to push cities to adopt compliant housing elements?
Yeah, I think that's its intended its intended use.
Right.
It is intended to be punitive. It is intended to be a stick for cities to get compliant housing elements. So in terms of how you would use this as advice for cities that are you want to sort of push your city to get a compliant housing element, I don't know. I mean, I'm happy to do this presentation for your city if you think it would help to show that. I mean, I think telling them what the law says is a pretty good way. And like I said, I've said this before. The 10 unit thing I think is actually maybe the scariest thing for many cities right? If you don't have a compliant housing element, that means somebody sitting on a single family parcel is going to be able to turn that into 10 units with no affordability. And that's going to scare your single family homeowners pretty bad.
All right, let's say a developer has already applied for a builder's remedy project and now they want to argue that the inclusionary zoning is infeasible. Wouldn't the city argue that they must have initially thought it was feasible?
So can you show me are you able to show me the question?
It's in the chat. Yeah, this is
Okay.
from Ms. Paulson. So I think it's the developer already has a builder's remedy project, which they now say the inclusionary is not feasible. And then this says wouldn't the city argue that initially it must have thought it was feasible? But I mean,
Oh, I think that what the question is saying is, so right, suppose that you apply, right, suppose the city has a 10% inclusionary, right? So you propose the project with the 10%, and now you want to argue under the new law that 10% makes your project infeasible, right? There, the city would respond and say, well, you must have thought it was feasible when you initially proposed the project, or else you wouldn't have proposed it. I mean, yeah, I suppose they would argue that, and you just have to argue to the contrary. In that case,
I mean, doesn't it seem like, I mean, things that are feasible in 1 year are not feasible 6 months later. I mean, everything changes. I mean,
yeah, that's a really good point too. Yeah, that 10% was feasible when we filled out the application, but it's not
yeah.
now. But yeah, I mean, I agree with you that the city can argue that for sure. And it's just going to be a question of marshaling your arguments in response, keeping in mind they have the burden of proof, and the statute is supposed to be interpreted liberally in favor of housing. I think Liz's point is a really good one. Other than that, I might have to noodle on it a little bit, but yeah, I mean, there's no totally foreclosing a city from making an argument, but I think that that's how you might respond.
Okay. We have a question about what does 45 dwelling units to the acre look like? That is such a loaded question. It can look like so many things. That's
I'm sorry, what was the question?
Oh, it's the question we get, like, people are trying to visualize what does 45 dwelling units to the acre look like. And it can just look like I mean, there's just so many different ways to do it depending on how your floor area ratio and, all that stuff. I mean,
yeah, it's not like I know with like the ADUs these days, there is the state has actually prescribed a standard kind of set of dimensions, so you can get an off-the-rack design for an ADU from a bunch of different companies. There's nothing like that for builder's remedy yet, although I wouldn't be surprised if some enterprising architects start coming up with model builder's remedy projects that max out the density. But again, a lot of it's going to be site specific too. So I don't know that I can tell you exactly what it's going to look like. And keep in mind, you don't have to do the maximum density either, right? I think for a lot of developers, 45 units an acre is going to be too dense. So no, I don't know that there's a template right now.
Okay. All right. What does comparable mean exactly in the affordable housing comparable bedroom and bathroom count? Exactly the same, or for example, 2 versus 3 bedrooms? Can we use density bonus concession to skip this?
Yeah, so
That's
sometimes, yeah, comparable, you have to assume the legislature puts a weasel word in there on purpose, right? Comparable doesn't mean it has to be exact, right? Or else they would have said it has to be exact. It just has to be comparable. But you're right. What does comparable mean in this context? If it's 3, if all the market rate are 3 and yours is 2, is that comparable? I don't know. Maybe you'd have to look at market comps to see what they're renting for 3 bedrooms versus 2. But I mean, I suppose I would read that to say it should be the same, right? But I think you can read it saying it doesn't have to be the same. It just has to be close because close is comparable. In terms of using density bonus concessions to skip this, no, because that's a state mandate, right? You can use the density bonus concessions to skip local standards, but not the standards that the state itself is prescribing.
Okay, under previous builder's remedy law, there was a builder's remedy light, which stated that cities couldn't prevent housing on land zoned for residential or commercial if they failed to identify sufficient sites to meet the RENA in their housing element. AB 1893 removed this section. Did this language get moved, and is it possible to still use this pathway or something similar under the new law?
So this webinar, I'm not really talking about the builders, what I call the builder's remedy light. So I know that D5A is still there. I wasn't aware that D5B was removed. Let me take a quick look here. Just be a moment. Hold on. No, D5B is still there. Or maybe it has changed. D5A is still pretty much the same as it was before with a couple of little quirks. So getting back to the question, yeah, it does look like that the D5B has changed somewhat. If the city doesn't, so it's going to be one of two things. Either the city doesn't have a compliant housing element, or they do, and your site is listed in the housing element. So, right, that's D5A. So I think those are kind of the two pathways. I don't know about this other pathway that this question's asking about. But if you follow up with me, we can look into that.
Okay, that's coming from Aaron Baral, who I actually know. He's a researcher at UCLA.
Okay, yeah, like I said,
Yeah.
this presentation wasn't really about that other pathway of under D5A and D5B. This was more about cities that have the non-compliant housing element, which is now under D6. So maybe we'll do another webinar on that one. But for now, I don't know about that. I have to think about that one.
Okay. All right. This person says they're a bit confused about the nuances of the 10 units or less. When reading the bill, it seems to be tied to the size of the property. And this person has a property of about 5 acres.
Yeah, I mean, so it has to be, I believe, at least 10 units per acre, and the site has to be 1 acre or less, right? So most sites are gonna meet that, because if you're building 10 units on a 1 acre site, it's going to be 10 units per acre. So I think if your parcel's 5 acres, then you're probably not going to be able to do it. The goal is not estate housing. The goal is to have the kind of missing middle type housing.
Okay. All right. 10 units is 10 total units. That's a statement. Okay, I think that's discussion about that. And then Aaron says that he will follow up with you. We would love to host any of the other scenario builder remedy lights. If you decide that you would like to move that forward, we would be happy to play host again and bring together all of these good folks with interesting minds and interesting questions who are out in the world researching housing in the case of our friend Aaron, or actually bringing housing to market, making new places for families and individuals to live, which is our goal at People for Housing. We are the Yes in My Backyard for Orange County, California, and we care about making sure that housing production meets the needs of the population that is here. And overwhelmingly, we are seeing that is a missing middle. Family sizes are smaller. Living standards are different than in the past. People are content with smaller spaces. And so we want to see more diversity in the housing stock, more apartments, condos, townhomes. And that's the goal for us at People for Housing, is to make sure that we can integrate some more diverse housing options and opportunities into the housing stock of Orange County, which historically has shouldered its preferences for freestanding single family homes, but those are really out of reach for today's population. So do we have any other questions? Anyone want to come off mute and ask a question or put another question in the chat? All right. somebody said. The new bill only says a builder's remedy project shall be deemed to be in compliance with the objective zoning standards, objecting subdivision standards, and objective design review standards for the purposes of complying with paragraph 5 of the subdivision, section A of section 65913.4, basically for SB 35, but you're saying it's also good for other CEQA, other types of CEQA exemption.
Yes, just give me a moment here. I'll point out the statute section for you.
Okay, cool. Because I wouldn't know how to do that. That's why you're here.
Okay, so this is in the statute section F6D3. Any project that complies with this paragraph, that means that is a builder's remedy project, shall be deemed consistent with an applicable plan, program, policy, ordinance, standard requirement, or other similar provision for all purposes. Okay? So as I read that, that means you are deemed consistent with any applicable standard for all purposes if you're a builder's remedy project. It doesn't specifically say infill exemption, but if you read the infill exemption, it says you have to be consistent with all applicable local standards. This is literally saying you're deemed applicable with all local standards if you're a builder's remedy project.
All right, and then we had one question that came in, and this is actually something I've wondered about, and I'm curious, because I've seen, we have a builder's remedy project in Orange County that's seeking to do this. So they're asking, can ADUs be the type that the piece of the project that is counted towards affordability? And I think the answer to that is going to be no, because of the comparability clause that you were just talking about. But you're the lawyer.
So yeah, under the original builder's remedy, yes, right? Because there is no there is no comparable thing. I know that this has been fought about a little bit, but I don't really see the controversy here. If the ADUs are deed restricted affordable, then they are affordable units. The whole point of the ADU laws is to make housing affordable. So if and it's a housing unit, right? You can't debate that it's a housing unit. So if the ADUs are deed restricted in the way that the builder's remedy requires the affordable units to be deed restricted, then absolutely they should count towards the 20% on the current builder's remedy. Now, in terms of the new builder's remedy, yeah, the only constraint is comparable bedroom and bathroom counts. So even if it's a different unit type, and even if it's smaller, right? If your main unit is your market rate unit is 2 bedrooms, 1 bath, then your ADU has to be comparable, right? As we already talked about what does comparable mean. Well, certainly if it's 2 bedrooms, 1 bath, that's comparable. If it's 1 bedroom, 1 bath, then then you've got an argument on your hands. Well, it's close enough, and this is an ADU, so it's comparable. So I think you could still make the argument even under the new law, but certainly I would think under the old law, there's no reason why ADUs should be treated any differently than any other type of housing unit. And I find it weird that cities have even tried making this argument because the ADUs shouldn't be treated like other housing units. Why not? The whole point of the ADU laws is to increase the stock of housing, of affordable housing. Of course, the assumption is it's naturally affordable, but if you're willing to deed restrict it affordable, that's even better. So I don't get the controversy.
All right. I agree with you. Okay, well, I think that's it. I don't see any more questions in the chat. Again, want to thank everybody for your time that you spent this afternoon with us, and many thanks to Ken for our ongoing partnership in this series, and we look forward to hosting you again in the near future.
Thank you, Liz. Thanks, everyone. It was great to be here. Appreciate all your questions.
All right. Have a good afternoon, everybody.